Good morning, everyone. Thank you for joining us today at the beginning of our online webinar summit. As you know, we have a handful of webinars scheduled through the course of the day, all with really great information, and we're very much disseminating it to all of our clients. And we appreciate your time and hope you can participate. So the first webinar today is being conducted by attorney Joe Bartulis. Joe is a partner at the 50 attorney, 6-office location law firm of Fletcher, Tilton, PC, where he's chairperson of the firm's labor and employment law practice area. He is also a member of the firm's education law practice group, and for 25 years, Joe has advised employers on all aspects of the employer-employee relationship, and he also regularly advises public school districts on education law and employment law matters. We're excited to have Joe do our webinar this morning. Joe's a regular on our webinars. He always does such a terrific job and we get great feedback. Today, Joe will cover the latest developments in labor and employment law, including but not limited to recreational marijuana legalization, the Pregnant Workers Fairness Act, the Massachusetts Pay Equity, the Massachusetts Bathroom Bill, and Trump's administration's impacts on employment law and regulations. So without further ado, I'd like to introduce you to Joe Bartulis, and he will take it from here. Thank you.
Good morning, everyone. Thank you. All right, so hopefully everybody's had their coffee today because the material can be somewhat dry, but I'll try to make it interesting as best I can. So again, my name is Joe Bartulis, and we're going to do a quick overview on some of the more important things. One of the things that frequently comes up, people will ask me about the new recreational marijuana law and what impact it does or does not have on an employer's ability to take action against their employees who may be under the influence of marijuana. So without further ado, let's kind of go into the recreational marijuana law. We will be covering quite a bit of material, so I'm giving you more of an overview, but at the end, I have a slide with my contact information. And by all means, if anybody has any questions, they can either call me or email me, and I'm happy to respond. Okay, so real quickly, in December of 16, following the November passage of the ballot question, Massachusetts became one of the states that now allows recreational use of marijuana. But there's a couple things we need to keep in mind. It's only legal for people who are 21 years of age or older. Similarly, marijuana is only allowed in certain instances. So where you can't smoke cigarettes, of course, you can't smoke marijuana at all as well. Similarly, there are requirements as to how much marijuana one can possess, whether they're at home or whether they are out in public, and a couple things like that. So that's what you want to kind of keep in mind. So the recreational law of marijuana basically allows you to use marijuana, but it doesn't necessarily mean that employers can't take action against people. So moving to the next slide here. So what are the kind of, under the law, it expressly provides that an employer does not need to permit or accommodate any conduct that would impede its ability to run its operation. Okay, the question had been, now that it's recreational, allowed recreationally, can that impede our ability to regulate what these employees do or do not do at the workplace? The answer, of course, is no. Okay, so one of the things I want to point out as well is we do have a Federal Controlled Substances Act. And under that federal law, it is still against the law to possess or cultivate any marijuana of any kind. That's why you may have heard a lot of these people, when they try to put their money, the dispensaries for recreational marijuana sales, they will frequently find that they can't put their money in certain banks because banks that are federally insured are prohibited from taking that money. Pot, as I point out on the slide, is still a Schedule I Controlled Substance Act, substance which is prohibited by law. Okay, so the question then becomes, if it's prohibited by federal law, what impact does that have on my business? Well, there is something called the Drug-Free Workplace Act, and the key takeaway for you listening to this is that if you are a federal contractor and or you get federal grant monies, the presumption is that you will comply with the federal laws as a condition of having that contract with the government and or receipt of that grant. So you may be bound to even take further steps to prohibit marijuana use in your workplace, even if you would otherwise allow people to recreationally use it. You may be precluded from letting them do so if you're governed by a federal contract or receiving federal grant monies. If you're not in either of those categories, then you're free to do as you decide as a business owner or operator. Okay, so the first question, I think the answer is obvious, but people ask, can I fire an employee who comes to work high on marijuana under the influence? And the answer obviously is yes. Just as you could take action to either discharge or discipline a person who is under the influence of alcohol, so too could you do so, take action against a person who is under the influence of marijuana at work as well. All right, and that's why I've got that practice pointer there. The legalization of recreational marijuana use doesn't change that ability of the employer at all. Okay. Now, sometimes people say, well, where is the new recreational marijuana law contained? I've just put a slide in there for your benefit so you can see it. But the new law is contained in Mass General Law. That's what the MGL stands for. Chapter 94, capital letter G, Section 2, subsection E is where you will find the marijuana law, should you be interested in doing that. So in face of the new law, we have some questions. And the questions would be, of course, what about drug use or drug testing? Now, what's interesting is many employers who do drug test will say that they drug test for everything from opioids to marijuana to alcohol to cocaine, a whole host of substances. And the question becomes, if marijuana is now legal recreationally, should I be testing for marijuana as well? And the reason why that question gets posed is because in Massachusetts and many other states, people have a privacy right to their bodily fluids and the like, and their saliva. And the expectation is that if I'm concerned about your ability to work, while that holds true for cocaine, while that holds true for alcohol, marijuana can remain in one's system and test positive long after all of the effects that it would have on one's ability to perform their work and the high have long since passed. So the question then becomes, do I want to discipline somebody for marijuana use that has nothing to do possibly with their work? They've done it over the weekend. It's now Tuesday or Wednesday when all the effects of the marijuana have worn off. That's a question every employer has to ask itself. But one of the tips I'm suggesting there is that if you're an employer who believes that somebody using marijuana on their own time on the weekend, so as long as it doesn't impede their ability to work, you're not going to test for that. There's nothing wrong with your deciding that while you will drug test, you won't test for marijuana. Okay. Now, as we'll see here in a few minutes, if you do have a drug testing policy, one of the tips is that it must be uniformly enforced and applied to all employees. Now, what I mean by that is as follows. If you are an employer and you're drug testing every one of the, I'm making it up, the people up in the control room at the airport, you should be testing every person in the position in the control room, not just testing certain people who may be of a certain age or who may work certain shifts. You should, if there's a reason to test people in the control room, you should be testing all of them or none of them. Okay, so I really break drug testing down into three categories. So first of all, as a prerequisite to doing any drug testing, the person must hold a safety-sensitive position, meaning that if he or she was under the influence of drugs or alcohol while doing their work, it would be difficult for them to do their work, and they or others could be harmed by their being under the influence. So if you're a pencil pusher or work at a desk, query whether or not that would actually rise to a safety-sensitive position. I would argue it may not. While it may be true that they may make accounting mistakes or other types of mistakes in their job, that doesn't necessarily mean it's a safety-sensitive position. So clearly an example of a safety-sensitive position would be anybody working with power tools, anybody working a backhoe, forklifts, so certain trades you would have that. Okay, so the first thing is before you drug test anybody, you should only be testing people in safety-sensitive positions. Why? Because again, the right to privacy is trumped when it's a safety-sensitive position favoring the employer to drug test. When it's the opposite, the expectation is that the employer would not drug test. Let's break down drug testing into three categories: pre-employment drug testing, drug and alcohol screening; reasonable suspicion drug and alcohol suspicion testing; and random testing. Now, with regard to the middle one, reasonable suspicion testing, if the person is not in a safety-sensitive position, but you still believe they've come to work or are under the influence at work, you can absolutely do reasonable suspicion testing, even of a person who's not in a safety-sensitive position. With regard to safety-sensitive position testing, that's where we're testing people who, but for their safety-sensitive position, I would have no other reason to believe they're under the influence, and I would probably have no other reason to test them. That would be the pre-employment and the random category. Okay, so looking quickly now at pre-employment testing, what must you do for it to pass muster with the Massachusetts law as it relates to the right to privacy of the individual being tested? The first thing you want to do is to let everybody who's being tested know that they know in advance that you will be testing them. Usually that would be in the application and or in the job posting on whatever social media posting board that you may use. You're letting people know this is a position for which if you get hired, you will have to go through a drug test. The second prerequisite for pre-employment testing of people, again, in safety-sensitive positions, is that you only do the drug testing after a conditional offer has been made. Effectively, you're saying, I want to hire you, I'm offering you a job, so long as you pass the drug and alcohol screening, you work for me. That would be when you could do the testing. You can't do it at the early stages to wean people out. You have to do first a conditional offer. And again, it's the offer is what gives you entree to doing this. Next, as I previously mentioned in a prior slide, if you're going to test people in safety-sensitive positions before you hire them, it should be all applicants for a particular position. Now, don't get confused. I'm not saying you have to drug test everybody. First of all, it's only safety-sensitive positions. But let's assume you're hiring for, again, using a silly example, air traffic controller. You would, in that instance, every air traffic controller you are considering for hiring for whatever openings you may have, each of them would be tested. Sometimes you'll hear people say, occasionally, not often, they'll say, well, I know this person I'm hiring is in his or her 60s. They don't usually, they're taking a broad stroke, of course, that these people are less inclined to use substances illegally. So I'm going to save a few bucks and not test that person because I believe that it will come up negative and I'm not going to waste the money to test. Absolutely can't do that. Every person in the position that you're hiring for, if you're going to test one, you've got to test them all. Okay. Now, with regard to reasonable suspicion testing, there are really no elements to put down. It really is your judgment as to when you have reasonable suspicion. But what I do suggest is this: have certain people in your organization trained to identify and determine whether they believe somebody is or is not under the influence of drugs and alcohol. Maybe it's the smell of alcohol, the smell of marijuana, the glassy eyes, the dilated pupils, the unstable on their feet, the slurred speech, whatever you think would be the elements that would give you reasonable suspicion. Once you believe you have them, you can then say, I'm going to subject you to a drug screen, and I'm going to have you do that right now. Now, a tip of the trade, if you ever do reasonable suspicion drug testing, you never, ever, ever want the person to go to the testing facility, him or herself. There should be somebody in your organization, a designated individual, who will bring them to a predetermined designated testing facility, because you do not want any of your employees, now that you're suspicious of their being under the influence, driving themselves to any of these testing facilities. Okay. Now, the next category of drug testing for safety-sensitive positions would be random drug testing. Now, I put random in quotes for a reason. Why? Because it can't really necessarily be truly random. The expectation is that over some period of time, everybody will be randomly tested. So when I say it's not actually random, what I mean by that is you should have some kind of a policy that 1/4, 1/3, 1/2 of all of your employees will be tested no less often than every year or 2 years or 3 years, whatever the case may be. 1/4 of your staff will be tested every year. So it's not random in the sense that 1/4 of the staff will be tested every year. However, similarly, there's nothing to preclude one employee from being tested twice in a year, while another employee may go 2 years. But in any event, at the end of the 2-year or 4-year period, whatever the period may be, everybody is tested. Okay, and again, it must be in safety-sensitive positions. Okay, so I'm going to give you a couple tips on some of these drug-free workplace policies and tips to have. The first one is that the law does not prohibit you from not hiring an applicant who tests positive for marijuana use. So let's assume you've got somebody, you do a pre-employment inquiry, and it comes up that they've got nothing else in their system except marijuana. Can you, in a vacuum, decide not to hire that person? Yes, I'll briefly describe in a few minutes a Barbudo case that may modify that slightly as it relates to people who have a medical marijuana use card, but anybody who simply uses marijuana recreationally, if you decide I don't want that person working for me, the law doesn't preclude you from not hiring that person. The law specifically provides that we're doing nothing by way of this law to limit an employer's ability to keep a marijuana-free workplace, okay, under that 94G that we spoke about, okay. Similarly, if a person who works for you already gets tested positive for marijuana, you can terminate them as well if that be your prerogative, okay. Now, the Barbudo case, which we'll be discussing, has to do with medical marijuana. But the key takeaway for you is absent medical marijuana use, recreational use by employees does not need to be tolerated by the employer, and the employer can terminate the employee. Okay. Now, let's go through some of the things you may want if you have a substance abuse policy. Okay, the first suggestion I have is a policy should be in writing, absolutely. The second tip I have for you is that your supervisors who are enforcing the policy should be conversant on what the elements of the policy provide and how to detect workplace violence of that policy. The policy should also talk about what conduct is prohibited and what the penalties are for violations. Now, one of the policies, of course, that I suggest you have in place, and I'm happy to review any of your policies should you send them over, one of the things I advise is that you make it absolutely a terminable offense to say you may not use marijuana during any part of your workday or any break from work during your workday. Rule number 1. Rule number 2, in no event may you possess any type of marijuana on the workplace premises. That I can preclude them from doing that as well, and there's absolutely nothing wrong with that. I indicate that you should detail who the policy covers and when it does and does not apply. Okay. Now, again, I believe the policy should clearly enumerate who gets tested, when they get tested, and what the punishments are for violations. Hopefully your policies provide for those things. If you do decide to discipline somebody, I always suggest that all discipline be consistently and uniformly applied. You do not want to, I hear these stories time and again, where somebody will say, my son-in-law tested positive for marijuana. I'm going to give him a pass and allow him to keep working. But then the next person who's not related to me or that individual tests positively, and the employer says, I'm terminating that employee. For consistency's sake, I think the best practice is that if you're not going to tolerate it, don't tolerate it across the board. And if you catch somebody using it, whatever punishment you believe is warranted in that instance should be then the barometer against which you benchmark any other discipline that's meted out against any of these folks. Okay. I believe that, again, if you think somebody's under the influence, you don't take disciplinary action against them until you have the test results back. Even though you know in your heart of hearts that they violated something, the purpose of the test is to confirm that, and that discipline shouldn't be meted out, I believe, until after the test results are returned. Now the question becomes, well, what do I do while I'm waiting for the results? You can either put the person out on paid administrative leave, so you're paying them to stay home because you don't want them to work, or you put them out on unpaid leave and say, you can't come back to work until I get the positive results. If you're a unionized workplace, I don't know if any of you are, there may be some different rules, but if you're a non-unionized workplace, that policy that I just described is fine. If you are going to interact with somebody who you believe is under the influence, of course, I suggest that it be a private interaction and you don't do it in front of somebody out on the shop floor. Okay. Couple things that I think all policies should provide. I give you a couple bullet points there, but visiting customers or clients, attending off-site work functions, attending work functions on-site, any off-site work event, or when you're driving company vehicles. Real quickly, I want to get to I had already mentioned these things, so I don't have to mention them again, but again, reasonably related, meaning it's a safety-sensitive position. A drug testing program is reasonably related to the use of a backhoe, the driving of a semi, or any type of motorized or electric equipment where dangerous could be. You may not have it reasonably related to doing data entry on a computer, for example. A couple points that I've given you there real quickly, again, are, do the employees have advance notice? What harm comes to employees if somebody was under the influence? These are things you want to keep in mind. All right, so real quickly, what do I want to tell you briefly about legal challenges employers face? I'm not going to go into all the minutiae on this other than to tell you that if a person is a medical marijuana user, that means they have obviously a medical condition. Under what's known as the ADA, at the bottom of this next slide, you'll see that it says an employer has an obligation to try to accommodate somebody's medical needs, and in this case, it may be the use of marijuana if there's a medical necessity. Now, under the ADA, the law provides that you only need to make a reasonable accommodation if, one, granting the reasonable accommodation will allow the employee to perform the essential functions of the job, and two, that if I make the accommodation, it will not cause undue hardship. An example of undue hardship would be if somebody has some heightened sensitivity to scents, and they say, I want you to put in a $10,000 filtration system on the air machine, on our air conditioner and heater, a small business, that would be an unreasonable accommodation. However, a person saying, can I move my desk 5 feet closer to the window so I can open the window, get a breeze, and my condition of the hypersensitivity to scents is ameliorated, is that okay? And of course, I would say that that is. So in the Barbuto case, what happened was Ms. Barbuto failed the pre-employment drug screen for a safety-sensitive position. She was told because she failed for marijuana use, she wasn't going to get her job. She produced a medical marijuana card, and the employer said, I'm unmoved by that. Goodbye, you're still not coming to work for us. She then came forward and said, I've been discriminated against. It had direct appellate review, as you see at the bottom of that next slide, by the Massachusetts SJC. And having done that, the SJC then said, let's go over the case. So the SJC, which is the highest court in Massachusetts, the Supreme Judicial Court, it decided that she could bring a discrimination claim for the employer having denied her the ability to be a medical marijuana user. And they said that you have to create an exemption for medical marijuana users from the strict enforcement of drug testing policies if you are doing so as a reasonable accommodation. Now, one of the points that was raised by the employer by Advantage Sales and Marketing was, yes, but it is a federal law that says that you can't, under the Controlled Substances Act, you cannot be a user of marijuana, so we want to rely on that. And they said, but you're not a government contractor, and you are not receiving government grants, and while she may be violating the federal law, it's not for you to enforce the federal law, so that's why they found the federal law violation was irrelevant. So what are the key takeaways from the Barbuto case? You can still prohibit the use or possession of marijuana in the workplace. It is considered still, employers have the ability to consider it per se unreasonable, and it is an unreasonable ask, and it's not an expected accommodation for you to allow anybody to imbibe, use, or smoke any marijuana-based product during their workday, regardless of whether or not they claim that it doesn't affect them and it won't affect them at all. However, If you believe that the person can use it outside of work, you must be expected to do that. So here's what happened in the Barbuto case. Miss Barbuto had Crohn's disease, as I said in a prior slide, and in her case, she was smoking marijuana 1 or 2 nights a week, maybe Tuesday, Thursday evenings, to ameliorate her condition. The effects of the marijuana that she was smoking at 7, 8, or 9 at night were long gone from affecting her ability to do her work when the morning came and she showed up at work. And in that instance, they said, because it's not impacting her ability to do her work, and because she's not under the impacts or the effects of marijuana at work, the employer is expected to accommodate her by allowing her to use marijuana recreationally on her own time, regardless of what their policy may or may not provide about outside use of marijuana. Now, an employer, even if an employee does use marijuana outside of work, are there situations where it still could create an undue hardship? Absolutely. If the use of marijuana outside of work means that when they show up to work, they're a little fuzzy and unable to perform the essential functions for the first hour, 30 minutes, 90 minutes of the workday, the employer never need tolerate impaired performance. Similarly, you don't need to accept any safety risk. So in the Barbuto case, if she was under the influence as she drove to work or got behind a forklift operator, whatever it is, in a safety sensitive position, she wasn't that. But if she were, you wouldn't have to accept that safety risk. Similarly, if you're a government contractor, you wouldn't have needed to accommodate her if doing so would violate a contract you have with the federal government. Okay. So the key practice pointer I point out to you at the bottom of that next slide is that post-Barbuto, I suggest that employers not have a blanket policy prohibiting failed drug tests from pre-employment employees or even current employees if the employee's failed drug test is related to marijuana and the employee presents you a medical marijuana card that says they can do it, unless, pursuant to the prior slide, you can establish that their use of marijuana is sufficiently close to the start of the workday that they're still under the influence when they come to work. In that case, it's different from Barbuto. All right. So practice pointer at the bottom there, I point out the undue hardships generally will be hard to establish, but if you can establish them, you can certainly run with them. Clearly, if somebody says, I have bad arthritis, I take marijuana or glaucoma, and I smoke marijuana as I'm parking, after I've parked my car in the parking lot of the company, and then they come in to work under the influence of marijuana, that would probably be a fine undue hardship. But failing that, you probably would have to allow them to continue to work. Okay. So with that, I'm going to quickly move into the next law that we're going to briefly be talking about is the Pregnant Workers Fairness Act. Under the Pregnant Worker Fairness Act, the law was passed this past July. It does not go into effect until April 1st of next year. Now, some of you may see there on the slide, there's a reference to what's known as MGL Chapter 151B. That's the so-called Massachusetts Anti-Discrimination Statute. Under the Anti-Discrimination Statute, it already provides and has provided for a long time that you cannot discriminate against anybody who is disabled. People who are pregnant are considered, for purposes of the anti-discrimination statutes, disabled, so that they have and they continue to have a vehicle by which they could bring a discrimination claim. This does not create necessarily a new vehicle for them. They've always had that vehicle. What this does is for pregnant workers and only pregnant workers, the law is expanded by the Pregnant Workers Fairness Act to create additional job protections for women who are pregnant that go beyond the anti-discrimination statute. Okay, so real quickly, if an employee is pregnant, you have to consider any accommodation requests they make, and the accommodations, again, pursuant to the ADA, must be granted unless you can establish that it would create an undue hardship. Okay, so what are some of the reasonable accommodations that the law expressly states in the law itself that if a person asks for these, they are considered to be per se reasonable and you must grant them? All right, so let's tick them off. If a person says, I need a slightly longer break, that will not create an undue hardship. The law is already saying you have to afford them the longer break if they need it. If they need more frequent breaks, you're expected to give it to them. If they need time off from work, you're expected to give it to them. Workstation accommodations might be, again, an ergonomic chair, a standing desk if they want one of those Veridesks or whatever they call that. Those would be workstation accommodations. Now, this next one I want to highlight is important because it's kind of counter to ADA analysis. Generally speaking, under the ADA, you only need to accommodate somebody who can perform the essential functions of the job. Because of that, there's an argument to be made that when one is seeking light duty, by implication, that means they only want to do part of their job. If they're only doing part of their job, there's an argument to be made they're not performing the essential functions of the job. So I point that out because that's a little bit contrary to the ADA analysis, yet the Massachusetts statute says if somebody wants a light duty accommodation, you should presume that to be per se reasonable and you should try to accommodate them. Same thing goes for job restructuring. Again, that's counter to the ADA. If you have a private bathroom, you should be able to let them use that, modifying their work schedule. And again, counter to the ADA, if someone says, I need assistance with manual labor, the presumption, of course, is that you would give it to them. Now, when I say assistance with manual labor, my reading of the statute provides that the assistance with manual labor would mean if you're a person who's supposed to load the photocopier with reams of paper, that you would say, can somebody else load the photocopier for me? That's something I can't do. If your only job is to babysit the copiers all day and run back and forth between the copiers, loading them with paper, you're basically relieving yourself or asking to be relieved of all of your essential functions. That would not be what I'm envisioning with assistance with manual labor. It's an occasional assistance at some point during the day or week where somebody else is helping you with, lifting or some other manual labor task that makes up a very small portion of one's job. Okay. Couple new factors that the law prohibits. They're pretty self-explanatory in the statute, but I just wanted to point out to you that, again, the employer, you can't preclude yourself or deny hiring a pregnant person who otherwise qualifies for the job and would be your selected candidate merely because he or she is pregnant. The second bullet point, of course, is that some employers will see an employee who may be 8 months pregnant and it looks like they, are going to have the baby at any time, and they say to the employee, I really think it's in your best interest to not come to work anymore. The law expressly provides that you cannot force an employee, a pregnant employee who believes she can still do her job, you cannot force her to take time off as an accommodation that you thrust upon her. Similarly, if you say to the employee, I just as soon have so-and-so help you with the lifting, or hey, do you want to take some additional breaks? It should, while the employer is welcome to offer those things if it be its prerogative, it cannot force an employee to accept an accommodation the employee has not asked for. Okay. Now, similarly, if the employee hasn't asked for the accommodation, and heaven forbid they had some health issue because of that, I would argue it wouldn't be the employer's fault because the employer hasn't forced them to do anything, and in fact, the person didn't ask for an accommodation, or better yet, they refused an accommodation that was offered. However, if they did get hurt at work, you'd still be subjected, I believe, to a workers' compensation claim, which again is beyond the scope of our presentation today, but I point that out nonetheless. Okay. Again, kind of obvious to this new law, you cannot preclude or deny somebody an opportunity, such as a promotion or assignment, merely because he or she has sought an accommodation, or not he or she, but she sought an accommodation for her pregnancy. Okay. So we've already kind of covered the undue hardship analysis, but a couple things I wanted to point out as to what you could argue might be an undue hardship would be the cost of the accommodation. I gave the example of a very expensive filtration system at a small business. The financial resources of the employer. Now, what do I mean by that? A $10,000 air conditioner change may arguably reasonable, maybe it won't be, but arguably reasonable for an employer such as EMC or Raytheon or some very large employer. Yet the mom and pop small shop who only have 6, 8, 10 employees, buying a $10,000 air filtration system would be per se unreasonable. The next thing you look at, of course, is the number of employees, the size of the business, to determine whether something is or is not reasonable. Okay, meaning, okay, you've got a data entry person who's asking to be relieved of certain part of her duties as a pregnant employee. If you've only got one person doing data entry, it may be an unreasonable accommodation to grant her what she's looking for. But if you've got 45 data entry people and now you're going to only have 44 doing that, the number of employees would indicate that it really isn't an undue hardship to grant the 45th data entry person the accommodation. Another factor is the type of business that you're in, to the extent that something may be reasonable or unreasonable. Okay. Now, one of the things that I get asked with some frequency, so I thought I would mention. So let's assume that an employee says, I can do the essential functions of the job, but I want to work during the day rather than the second shift. I want to drop down to the day and have the day person work my night shift because I don't want to be out at night given the fact that I'm pregnant. The law is pretty clear under the ADA and even under the Pregnancy Fairness Act that it is per se unreasonable generally if an employee asks an employer to displace another employee. Displace another employee means displacing him or her from the work they do, displacing him or her from the place where they do their work, or displacing that other employee from the hours in which they do their work. That is an unreasonable ask. So in the example of the employee who says, I want the cubicle right near the window because I have seasonal affective disorder and the sunshine will be very helpful to me and the fresh air coming through the window will be helpful. If there is a more senior person who has that coveted cube by the window, the employer, it's not unreasonable for the employer to say, I will not displace Susie Snowflake from her cubicle by the window, even though I agree that that would be an accommodation for you. Now, can you go ask Susie Snowflake if she would be willing to switch? Absolutely you can, but you cannot or should not be expected to force Susie Snowflake to be displaced to accommodate this other person. I mentioned you should use an interactive process to determine whether or not you can grant an accommodation. Now, there are certain things, generally speaking, when an employee says, I need an accommodation, historically, when you're doing an ADA analysis, an employer may request medical documentation to establish that the person really does suffer from a medical condition and needs certain accommodations made. You absolutely may do that under this new law. However, if the request comes under the following 4 or 5 bullet points, you cannot ask them to provide medical evidence. The mere fact that they're pregnant, which they've established for you, if they ask for certain things like more frequent or longer breaks, more frequent restroom visits, they ask that they not be required to lift over, say, 20 pounds, or they ask for a different seat or the ability to stand or the ability to sit from a standing job, the law says you should not be expecting the employee to go get a doctor's note to establish the need to take more breaks, more restroom visits, the ability to not lift over X amount of pounds, or being able to sit down during work. Why? Because those are, in the eyes of the legislature anyway, givens. And because they're givens, the employee shouldn't have to go get proof of those things because those, again, are the givens. Okay. Now, these are anti-discrimination provisions. What the law does provide, and it won't go into effect until April, of course, so you don't have to do anything this moment, but you should have a handbook revision, and I'm doing these for folks now, and I'd be happy to do them for you folks, but to revise your handbook to basically capture the elements of this new law. It should be given to all employees who currently work for you, and it must be provided to new employees from April 1st of next year on at their time of hire. If you fail to do so, they could recover damages, attorney's fees, cost, and possible injunctive relief as well. So with that, I will move now in our whirlwind presentation on these topics The transgender issues will be the next thing I will briefly talk about. The key takeaway for you folks is this. I've got a lot of stuff in there for you to review, but the key takeaway is this. You cannot discriminate against anybody who is transgender. In the fall of 2016, the MCAD, which is your Mass Commission Against Discrimination, prepared a guidance on gender identity discrimination. It is absolutely precluded, and you cannot discriminate against anybody because he or she is transgender. All right, now, I've got a couple rules there. You're welcome to read them at your leisure, talking about disciplining and discharging people. Again, you can't do it. Now, one of the things that I would point out to you, and this kind of dovetails in with the so-called bathroom rule, is looking at that fourth rule at the bottom. Employers may not prohibit an employee from using the employee restroom he or she identifies with. And so let's assume you have a person of one gender who has historically always used one bathroom. The minute he or she says to you, I identify with the other gender, and that's the other bathroom, the bathroom assigned to the other gender is the one that I want to use for my good faith, reasonably held belief that I'm now transgender, you must allow them to use that restroom. You cannot say, well, but I don't see any change in your dress style. I don't really believe that you are not transgender. The minute somebody tells you that they identify with the opposite gender, you're expected to give them a wide berth and to allow them to use whichever bathroom he or she identifies with. Now, the law does provide that if something were to happen in that bathroom and somebody was using it for the wrong purposes, a man going into a woman's bathroom, for example, that person can be criminally liable. That is the employee who went into the wrong bathroom for having done so. But so what I suggest again is you revise your employee handbook policies to address these transgender issues. Again, I'd be happy to do that if you wish. The third bullet point down is one of the points I want to make is most employers, I suggest, should make dress codes gender neutral where possible, so that, for example, you wouldn't necessarily say all women must wear dresses or skirts to work every day. Women can wear pants the same way men can wear pants, and conceivably, if a man were to show up in a dress, if women can wear dresses and this man identifies with the female gender, he should be allowed to do so as well. Okay. Next thing I will move into, and again, if anybody has any questions on any of the stuff I've talked about, you're welcome to give me a call and to email me with any questions. I'd like to briefly talk about the Massachusetts Pay Equity Act in the time we have provided today, and a couple key things about the Massachusetts Pay Equity Act. Some of you may be familiar with what is known formally as the Lilly Ledbetter Federal Equal Pay Act, and they'll say to themselves, I thought we already had a statute that protected us federally, this Lilly Ledbetter Act, and we do. The difference, though, as you'll read in this Pay Equity Act, is that under the Lilly Ledbetter Act, it's you must pay everybody the same pay for the same job. So Lilly Ledbetter worked on an assembly line, I think at a Goodyear tire plant down south, and in her case, she was making less than the male employees to her left and right on the assembly line, and it was established that she earned less because she was a female. In that case, they said because she's doing the exact same work as somebody else who started on the exact same day, it's equal pay for equal work. It's the same, same pay for the same work. The Massachusetts law is different. It says it's equal pay. Behind New York and California, we're the third state to do this. It is equal pay for comparable work. So this is an expansion of the federal law because not only is it equal pay for the same work or equal work, but it's equal pay for comparable work. Well, if you can imagine, comparable is a very subjective standard. So there could be all kinds of litigation on this. This law, by the way, does not take effect until July 1st of 2018, so it's nothing you need to address right now. But so then the law goes on to say, even if people do have either the same job or even a comparable job, you may nonetheless pay people differently in certain instances where certain things exist. So what are some of those things? Okay, well, before I say that, you cannot impose pay secrecy policies, and there are rules about using salary history. So in the time we have left, I'll just mention to you, as it relates to pay secrecy, as we'll get into in a future slide, the takeaway for you is this. Starting next July 1st of 2018, employers cannot tell employees that they cannot talk among themselves about what they earn or don't earn in their positions. So employers who have policies that prohibit that, those policies will no longer be enforceable. Similarly, starting next July, it will be inappropriate for a prospective employer to insist that a prospective employee tell you his or her prior salary in being considered for the job. The reason for that, of course, is that if you, as a female, were paid far less than your male counterpart at your old job, and you're trying to get rid of that by moving to a new job, if the the new employer benchmarks your salary on what your old salary was, hoping to give you an increase, but again, not a sizable one at that, they're just perpetuating this inequity, which is why they don't want to have the new employer ask questions about the old employer. There's still instances when you can get that information, and I will, very briefly address those here in a moment. Okay, and there are penalties for noncompliance, which we'll briefly highlight. So what is comparable work? It's performed under similar working conditions, and it goes beyond the job description. Okay, now, the particular of the pay secrecy provisions, I pointed out to you that under the pay secrecy, an employee starting next July can't be prohibited from telling or asking another employee what he or she earns. Now, the other employee doesn't have to respond, of course, and can say none of your business. The question sometimes gets posed to me, may an employee walk into HR and say to the person in HR, I would like to know what Susie Snowflake earns. Will you tell me, please? The law is very clear. HR is not obligated to give you, the person asking, information about anybody else's pay. Only thing the law provides is that the employee is welcome now to disclose what he or she makes to anyone else and to ask anyone else what he or she earns. There's no obligation to affirmatively respond when asked, nor is there any obligation for HR to provide that information to any other employees. Okay, now, real quickly, I had mentioned there were ability to have different variations in pay for the same job or even comparable jobs. So I'm going to rattle off just a few of the various benchmarks that would apply to that. So one of them would be seniority. If one person has been with you a lot longer than the other, or some period of time longer than the other, that would justify paying them differently. If one person works out in Western Mass, for example, where it's much cheaper to live and the commute is much shorter or whatever, you could have one rate of pay for Western Mass and a different rate of pay for Eastern Mass in relation to the fact that it is much more costly to work and do that job in Eastern Mass, and maybe I have to pay a lot more to get people to even do the job in Eastern Mass. Similarly, if one has a lot more education than the other person, or I shouldn't say a lot more education than the other person, and the educational component is a factor in doing the job, then that can be considered. People say, what do you mean by a factor in doing the job? If I have a PhD in chemistry, but I'm working a forklift, yes, I have more education than the people to my left and my right, but my chemistry PhD is not useful at all in my being a forklift operator. So that would be the example of why you could do that. Similarly, if one of the jobs involves traveling and the other does not, you can again pay the person who travels more some extra pay. So what are the penalties for non-compliance? You would owe the person the unpaid wages, which would be the difference between what that person earns and what the other individual who's paid more for the comparable job would earn. Liquidated damages, that's code for doubling the unpaid wages. So if one person earned $60,000, the other earned $50,000. At the end of the year, the unpaid wage component would be $10,000. Liquidated damages would be an additional $10,000 on top of the $10,000 unpaid wages. The attorney's fees, you have to pay, the employer would have to pay the reasonable attorney's fees of the attorney who represented the employee who had to go after the employer to get what was rightfully his or hers, the difference in pay. And finally, you would be responsible to pay their court costs, the filing fees and any fees, the delivery fees, summons fees, any of those things through the court. All right. Now, what the law does provide, we won't be spending much time, obviously, on this, but what the law does encourage is for employers to do these self-audits, if you will, going through all of their job titles, all the people holding those jobs, and trying to remedy the deltas between these jobs. And so what the law provides is that if you go through that process and you decide that, Susie Snowflake makes 20% less than John Doe, but we don't have the ability to give her a 20% raise right now, if through self-evaluation you decide that you're going to slowly bring Sally up to what Johnny makes by giving her an extra 5% raise over each of the next 4 years, the fact that if Susie or Sally calls you on it and brings you to court, you would be absolved from having to pay the liquidated damages and the attorney's fees because you are undertaking the correction of these things. The law wants people to do those corrections, and they want to give the benefit of the doubt to the employers for having done so. Now, one of the questions people sometimes ask me is, what if when I'm doing this, I see that John Smith makes $4 more an hour than the other 12 people in that department, and they're all women, and he's the only man in the department? Can I simply choose to reduce John Smith's salary to bring it back in line with the other the 11 women who also work in that department? And the law says no. This isn't an effort to try to reduce one person's salary, the higher paid male, to reduce it down to the female's salary. The government wants you, or the legislature wants you, to make the correction in the upward direction. Now, maybe what that means is that John Smith gets no raises for the next 5 years, and each of the other employees gets a dollar raise over the next 3 or 4 years. But that would be kind of how you would go about doing that. And I've kind of walked you through what those things would be. So the employers may use self-evaluations. It requires good faith, and it requires a working progress, which I mentioned, that kind of that stair-stepping going towards eliminating that disparity. Now, the last thing I will do in the last couple, 3-4 minutes we have are some of the so-called Trump effects, if you will, on labor and employment law. Okay, so the first one, if you've been following the news of late, is the so-called repeal and the replace of what's known as the Affordable Care Act, also known as Obamacare. They've made several efforts to try to do that. To this point, nothing has been done, but that's one of the things that we're going to be on the lookout for. Another one would be the decrease of funding for the DOL, which is your Department of Labor, and the EEOC. Why is that important? Because those agencies suffered an increase of funding and staffing over the Obama administration. And as you know, the more money an agency has, the more agents an agency has, the more feet on the ground to do investigations for potential violations by employers under the Department of Labor regulations and or the EEOC regulations. Conversely, if you defund or decrease the funding for those agencies, that leaves less agents to investigate, fewer employers to be investigated. So that's one of the things to keep in mind for that. You may recall a year ago, December of 2016, there was to have been a change to what is known as the salary basis test under the Fair Labor Standards Act, which said anybody who is paid a salary rather than hourly must, instead of earning more than $455 a week, which is the current standard, they need to earn over $950 or thereabouts and change per week. That law was to have gone into effect last year. It was stayed by a Texas court. The executive branch, the Trump administration, has indicated It will not file any type of appeal on that, so that the Fair Labor Standards Act salary basis test is effectively dead in the water. Now, there has been some rumblings that the administration is mindful of the fact that the $455 a week salary is such a low salary that really does need to be increased, but it doesn't necessarily need to be increased to the 900 and change that had been previously discussed last year. I believe had the Clinton administration come into play, I think that the salary basis test may have continued to have been appealed, and that would have been processed. You may be familiar, maybe you're not, with something called the joint employer doctrine. Basically, that has to do often with franchisors and franchisees, where basically if you are a major food chain or coffee chain or the like, and you have a franchisee who's violating the law, the deep pocket goes to the franchisor, the national brand, and that an employee could sue the national brand on the theory that they're a joint employer, meaning they're also my employer because I work for Acme Foods serving, snacks at their kiosk, and Acme Foods headquarters and, wherever it may be, making this up, that they would be responsible as well. So that's one of the things to keep in mind under the so-called joint employer doctrine. That has been expanding over the last 8 years, or the prior 8 years, and the discussion is now that they're kind of reining that in. I won't go into any details. This is really something extra I had today on the non-compete agreements, but I just thought I'd mention it nonetheless. Very quickly, if you want to have a non-competition agreement to be signed by any of your workers or employees, there are key elements for those things to be enforced. You may also hear the moniker restrictive covenants. A non-competition agreement is a type of restrictive covenant. So what are the key elements? There are really 3 things that a non-competition agreement is intended to do. It's intended to not have you do something. That's number 2, the breadth of what you can't do. For how long, that's number 1, the duration for how long you can't do what it is that you can't do. And the geographic area is where you can't do, what you can't do, for how long you can't do it. Those are really the 3 key elements of a non-competition. All 3 of those must be reasonable in duration, reasonable in breadth, and reasonable in geographic restrictions. If they are found to be unreasonable, it will be subject to what's called the blue pencil rule, where the court will modify it. With regard to duration, it is per se unreasonable if it's longer than 3 years. It's usually per se reasonable if it's a year or shorter. If it's 2 years or 3 years, those are judgment calls, but it should never, ever be more than 3 years. And the breadth of restrictions, what does that provide? It requires that the breadth of restrictions, if, for example, you sell heart medication to doctors, your agreement might be that you won't go to work for another company selling heart medications. That would be a reasonable breadth. What you can't do if you're the employer of the heart medication, say to this employee, you cannot sell pharmaceuticals to doctors if you're selling dental supplies, for example, or something else to doctors that has nothing to do with heart medications. So with that, my last page there is, again, the concluding slide is my contact information. Again, my name is Joe Bartulis. I'm the chairperson of Fletcher Tilton's Labor and Employment Law Practice Group. My phone number is 508-459-8214. My email is jbartulis@fletchertilton.com. Thank you so much for listening.
Thank you, Joe. I appreciate your time today. And I'd just like to remind everyone, if you need to get in touch with Joe, obviously his information is right there. You can also feel free to connect with us, and we would be more than happy to forward your information along. So in about 15 minutes, we'll be starting our next webinar, and we look forward to seeing you there. Thank you very much.